everybody. Welcome to our licensing subcommittee. A few introductions first. I'm Councillor Richard Morgan, who will be chairing the panel this morning. On my right is Councillor Lyon and Councillor Mead, the three of us, and our fourth member who is observing really, in case we get anybody objects to one of us. So you'll be just observing, and that's it, fine. We have our legal representative here, and also Democratic Services. If you'd like to all introduce yourselves, if you.
So I'm Andy Newman of Andy Newman Consulting Limited, and I'm the licensing consultant for the applicant.
My name is Dennis Fisher. I act for Sam in a legal and financial capacity for his business.
Morning, Mr. Chairman and everyone here. And my name is Vasant Karupasamy, and I'm the applicant.
Okay.
Thank you.
And this side?
I'm Anna Sami and one of the objectors and owner of 1 to 3 Smarts Lane.
Okay.
I'm Stuart Richardson. I'm one of the residents, neighbours directly behind the premises that's applying for the licence.
All right, well, we have David King, our licensing manager, and
Mrs. Handon Ibrahim, licensing officer.
okay, thank you. So how we conduct the meeting is that our licensing officer will present the case, and then it'll be the applicants to put their case to us. We will ask you questions on the application. The objectors will ask you questions only to start with, just on questions. It'll be then that the objectors say why they're objecting. We shall ask you questions, and then you will ask them questions. It comes to the end, we'll all just have a final summary up, both sides, just do anything new that has come up. We'll probably retire and consider the application, and then come back to you when we've decided. I think that's it so far. So we'll ask our licensing officer to put the application to us, please.
Thank you, Chair. Good morning. We're here today to determine the application for a new premises licence under the Licensing Act 2003. An application has been made by Indian Street Drinks and Food Company Limited for a new premises licence in respect of Grand Cholan, 154 High Road, Loughton, IG10 4BE. The applicant is applying for the following licensing activities: supply of alcohol on the premises Monday to Sunday 1100 hours to 23:30 hours, provision of recorded music indoors Monday to Saturday 0800 hours to 23:30 hours, and Sunday 11 to 23:30 hours. Hours the premises will be open will be Monday to Sunday 0700 hours to 0000 hours. The application was received on the 16th of April 2024. The operating schedule sets out conditions which will be attached to the licence if it is granted. When considering the application, the authority must have regard to steps that are appropriate to promote licensing objectives, which are the prevention of crime and disorder, public safety, the prevention of public nuisance, and the protection of children from harm. The responsible authorities have received a copy of the application. It was also advertised at the premises and in a local newspaper. The authority has received representation from Loughton Town Council, 2 objections from residents, which have been attached. And these objections relate to the prevention of crime and disorder, public safety, the prevention of public nuisance, and the protection of children from harm. Ms Kelsey Dott of Essex Police Licensing has agreed conditions with the applicant, and these conditions have been attached. The conditions which have been agreed are as follows. At all times, whilst the premises is open for the licensable activities, there are members of staff available to immediately provide viewable copies of CCTV recordings to the police or licensing authority staff upon reasonable request. All staff engaged in the sale of alcohol on the premises shall have received training in relation to the protection of children from harm, including underage sales, how to recognise drunkenness, and the duty not to serve drunk persons. Refresher training shall be carried out at least every 6 months. Training records shall be kept on the premises for a minimum of 12 months and be made immediately available to police, trading standards or licensing authority staff. Finally, I would like to bring to the attention of Chair and members that additional late submission was provided by the applicant and has been added as supplementary documents 1 and 3. The applicant's agent will go through these as part of his representation. Thank you.
Thank you. If you'd like to present your case, I think most of you know to put the microphones on and then turn it off when you're finished.
Could you put yours up? I couldn't hear you. No, I meant when you're speaking.
Thank you. Thank you, Chair. Well, I'll start off by saying apologies for late submissions. I was appointed Thursday afternoon, so before the weekend it wasn't ideal, and I'd like to thank some of those making representations for taking the time to attend. Right. Okay, so I'll be brief with this part, but as said, the application is for Indian Street Drinks and Food Company Limited for new premises respective Grand Cholan 154 High Road Loughton IG10 4BE, and applying for supply of alcohol on the premises Monday to Sunday 11 a.m. to 23:30, provision of recording music indoors Monday to Saturday 0800 to 23:30 and Sunday 1100 to 23:30. We have the opening hours, but that's a licensing matter, is another matter. But right, so we would say that this is a highly meritorious application. My client, we have the director here, who everybody will be pleased to hear goes by the name of Sam to make life easier for others. I call him Vasan, so I've got to change my mind. So this is in this area, it's by a new operator, and naturally the committee will know this, it's each application on its own merits. So if I could take people, please, to start off with, thinking which way to go, but if we can go, please, I think it's supplement 2 to legal and policy points that are submitted to the committee.
You got them all.
Supplement 2. Sorry, can we get some clarification of what page you're looking at and where, because I'm struggling with this.
I'm sorry, so I couldn't open the... we couldn't get the Wi-Fi on in time. It's...
The late supplements that you submitted?
Yeah, it was the one I submitted via Denise that went on. Beforehand.
That would be helpful.
Thank you. I've got almost everything else, I can return it, but I'm grateful. Mr. King, that's supplement 3. I believe it went on before then. I'm sure. It is in supplementary bundle for the subcommittee, I believe.
Chair, regretfully, the agent for the applicant submitted these in piecemeal form. There was a number of emails that come through, all of which I believe have been included in that bundle. So rather than being submitted in one bundle, unfortunately they've been submitted separately. Why don't you talk us through your points, Andy? That might be easier.
Yes, certainly. So, wasn't too, but anyway. Right, so the relevant points, there are no remaining representations from any of the statutory licensing authorities. That means that each and every statutory authority, which is each recognised in law as an expert in their own field, do not believe that the licensing objectives will be in any way undermined by the granting of the application. This includes the police lawfully recognised as the lead authority for crime and disorder. So I've also included Toulson, LG Hope and Glory, Court of Appeal, who mention the demand for licensed premises, economic benefits to the proprietor and to locality by drawing in visitors and stimulating demand, effect on disorder, but a weight of competing needs. And what conditions should be attached to licence as necessary and proportionate to promotion of statutory licensing objectives, essentially a matter of judgment, a matter of pure fact. And then I've included the decision of the High Court of Daniel Thwaites versus Wirral, where the licensee successfully reviewed that decision. Mrs. Justice Black concluded that, well, essentially, it's any decisions need to be made by evidence, and that the statutory licensing authorities, each legally recognised expert in their own field, didn't have any concerns regarding what have you. That must be, in essence, you've got to be very careful if steering away from the views of the experts. And as said here, all the experts are satisfied that the licensing objectives will not be undermined. I've also mentioned in section 182 to the guidance to the Licensing Act, which the committee must have regard to, which is a key medium for promoting fairness, equal treatment and proportionality. And as the committee will know, recognising the important role which pubs and other licensed premises play in our local communities by minimising the regulatory burden on businesses, encouraging innovation, here I'll come on to South Indian cuisine, and supporting responsible premises. And I'll go on to talk about Sam's history. In fact, I'll start now on the history. Start the same page. So, Sam's a proven operator. TripAdvisor ranked 167 out of 15,119 restaurants in London. His excellent relations with neighbours at the restaurant. I'll come back to the background evidence, which has 3 neighbours in close proximity to his Canary Wharf restaurant that state what a good operator he is and what a good neighbour. Sam is a passionate advocate for Southern Indian cuisine. There are no other, we don't believe there are any other restaurants in Loughton which caters for this level of cuisine. In fact, we believe the nearest is in Debden, in Langston Road. And also draw your attention, sir, to Epping Forest licensing policy, condition 133, that licensing conditions will be tailored to individual application and appropriate to promote the licensing objectives will be imposed. Licensing conditions will not be imposed where there are other controls or legislation exist to provide sufficient protection to the public. So we would respectfully say that there are other laws elsewhere for some of the stuff. I'll come back to it. And then if we could go, please, to supplementary agenda 3. So page 25. We have, this is where we have Rima Begum stating essentially what a good neighbour Sam's Restaurants is. And below, starting on 25, going to 26, we have Miss Sybil Yaga saying the same. And there's another one somewhere which perhaps Handan Ibrahim could assist me where it is, because I couldn't see the page, with yet another resident saying what a good neighbour and her close proximity. Grandcholan in the Canary Wolf restaurant even, that has in 2022, Grandcholan, which is an award-winning restaurant, gained the Rising Star Indian Restaurant of the Year 2022 and Best Restaurant of the Year 2023 from the East London Hospitality Group. So, and there's some lovely pictures as well on page 38, I should have said. But I'll conclude by saying that this is a highly meritorious application. Sam has a proven history of excellence. In fact, he's been in the hospitality for 15 plus years. He's worked with many auspicious people, very experienced, and we would say that this will be a welcome addition. We would urge you to, if you're so minded, to approve this very meritorious application because it's offering something new, something different with a highly responsible, acclaimed restaurateur. Thank you.
Thank you. Questions? Councillor Lyon.
Yeah. Looking at the application, there was a reference to a diagram of the actual restaurant layout. Just trying to find that now. But all it's got is the front entrance. It doesn't give any information about any other entrances or windows. Could you elucidate on that for us, please?
Yes, sir. One moment, I'll confer with my colleagues. Thank you.
There's the entrance door and the main front window on the high road, and then there's a rear door at the back of the premises. Other than that, there's no other windows, as it's a part of a terrace, 156 to the right and 152 to the left, if you're looking from the high road.
So there are a number of representations about noise and disturbance and access at the rear and alleyways. Could you explain how you're dealing with that?
Yes, sir, I can explain to an extent. My colleague to the right can probably explain further when it... I don't know if we want to go further into the weeds on the representation side. However, in terms of allegations of noise and so forth, firstly, danger of repeating myself, all the statutory responsible authorities are satisfied. I'll go further. Secondly, Sam did agree to, well, actually he agreed to all 5 proposals, but we found on visiting the site that they might breach certain other laws by doing them. But essentially, sorry, I'm trying to find the page, give me a second. But there will be a policy to ensure or to minimise any potential outbreak of noise or disorder or anything that may adversely affect residents. Sam, with his other restaurant, he does have a comprehensive suite of policies for this application. He's currently speaking with the last operator from TNG, Georgina Whitney. Also, we want to see what's said in the hearing to get a proper steer on how to phrase that policy and make it as comprehensive and pertinent as possible. And then one moment. So on supplementary agenda 3, page 42. There were 5 matters that were earlier agreed by Sam. So, if I may read them out. Have you got right, so I will go in a different order if I may. So I'll go from point number 5, which I believe is the next page, which was agreed. All deliveries, including Uber Eats, Deliveroo and all other online platform drivers, will only use the front door to collect the packed food. No delivery drivers will access the rear door. The policy will be strictly maintained as we do not want to create noise and air pollution for our resident neighbours who live above or next to the premises. So that's been agreed by Sam, offered, agreed. Number 4, smoking by staff or customers will be only permitted outside the front of the restaurant, not the rear, where we can clearly see the windows of people living immediately above and next to the restaurant, strictly followed and adhered to. And also number 3, as long as the waste disposal people can facilitate this, to organise the waste bin collection from between 8 AM and 6 PM, not before or later. And then the 2 that I put in question is to keep the bins always locked and closed. That's agreed, apart from the necessity to put stuff into them beforehand. The danger with conditions is that sometimes they can be written in such a way to make it impossible to operate. And in terms of number 1, to keep the rear door always closed, it will be open and closed only to put waste bins or receive deliveries from our suppliers. The problem is that is the one which in detail conflicts with other laws and procedures from the fire service and from health and safety at work. So that's where the policy comes in, that it's going to be an active document that is going to be put together, but when we have all the relevant information. Does that answer your question, sir? So then, and I'm told there's just one bin, if that helps. If there's anything more you'd like me or my team to elaborate on. please ask.
I think that's fine.
Okay, just wondering, these photos here of garbage all on the side of the road, are they to do with the premises? How do we get this?
Are they my photos? Sorry, can I?
I'll ask the question in a moment, yeah?
Okay.
Just ask, they are from the same premises, that on page 6 and 7.
I believe they are. They were submitted by the objector, Anna
Okay, right.
Sammy, so she'll be able to clarify exactly the location of those pictures.
I think that may have been some time ago from a previous operator. This restaurant has not yet opened, so it's nothing to do with the Grand Shoal, and it will not happen.
Miss Sammy was very honestly and helpfully nodding her head in agreement at that. Is that right? But I know you're going to expand on your representation, Mark.
Okay, thank you. Any other questions? Councillor Lyne? Councillor Mead?
Yeah, so could you let me know, so this layout on page 35, is that the current layout? Will that be the same layout, or is this the old layout from the previous owners?
It's a great question.
It's the old layout. Yeah, I believe that's the old layout. Materially, there's not much difference. It's just that the individual layout of Sam's restaurant will be slightly different from what was a tapas bar. Have you got a specific question about the particular layout you're looking at? All right, okay.
So you're going to keep it similar layout? It's not much different? Yes. Yeah.
The customers at the front, the toilets in the middle, kitchen at the rear.
And can you just remind me what's at the back of the restaurant? Is that just an alleyway? There's no sort of garden area?
Okay, well, that's obviously the issue that I think is the main objection. There is a very small alleyway which leads onto an area called Smarts Lane Mews, which was conveyed in 1948 with an easement right, which I think has been submitted and I can quite happily go through when we get to that point.
So at the back of that alleyway are the private gardens from the houses backing on, is that correct?
Mum, if it would help, I think it may be easier to dig into this area when at the representation stage, just for clarity. Yeah. Thank you.
Okay. Regarding the smoking, so you're saying that is that staff and guests are going to be smoking on by the front door of the restaurant along the street?
All guests and staff who wish to smoke will have to smoke on the outside, on the high road side. Any food that Sam sells to be delivered, takeaway, is going to be collected from the front of the premises. So there will be no issue of nuisance being created by motorbikes, delivery drivers, etc., at the rear of the property, with the respect in mind to the neighbours and the adjoining properties.
So I just want to be clear. So this is a restaurant stroke takeaway, and there's going to be motorbikes collecting the food and delivering. So it's a bit of everything. Is that right?
It's a restaurant, but with every restaurant currently, there's a takeaway service, but it's not a takeaway. It's a restaurant where people can order the food to be delivered to their homes. And
can you just remind me exactly, so the times about the live music, is there going to be any noise limiters? Has that been agreed? I can't see that. I might have missed it. Apologise if I have. But
sorry, no. Correct me if I'm wrong. There's no live music applied for. It's recorded music.
Okay. Well, for recorded music.
Right. Just left it with you. So that was till 2023-30.
Yeah. But who's going to who's going to check how noisy the music is, how loud it is?
In a second. On speaking with Sam, it would appear that the recorded music is on the cusp between background music, which isn't licensable, as you know, and day to day. Is that correct? Thank you.
Thank you.
Any other questions? Councillor Lyon.
Just on that connection with the music, is there any noise limiters in the place to actually keep the noise within a reasonable limit? Because if there isn't, how do residents deal with that?
Thank you. There are no noise limiters here, not asked for by, I was going to say environmental health, but community resilience. This is not going to be operated like some sort of nightclub or, well, you know, it's a pertinent point, sir. This isn't, the food is a star, it's an Indian restaurant. In these circumstances, operators normally manage the noise, you know, it's their responsibility under the Act to promote licence objectives, make sure they're not undermined, and ensure they're at the right level. People often talk about noise limiters. Operators can get simple apps or just listen, send somebody out and listen to ensure that the noise isn't too loud.
Just on the smoking and outside the restaurant, or people outside the restaurant, on that diagram, page 35, you've got the entrance. Is there anywhere in front of the restaurant where there is an enclosed space, or is this just people hanging about outside smoking? You know, is there going to be seats, or is there going to be anything available to actually manage that?
Well, currently there is nothing. It's just simply the high road. It's not something I particularly subscribe to, smoking, but if people wish to smoke, legislation was brought in by the central government that they have to go outside of the premises. We are not allowing anyone to smoke at the rear of the premises, which would interfere or cause a nuisance to adjoining properties.
Further to that, it will be the responsibility of the licensee operator to ensure that those people that smoke outside, and it's quite common along that part of Loughton High Road, for people not to be seated but to be standing, but it's incumbent on all operators to ensure that the licence objectives aren't undermined and that any smokers that go outside, that reasonable steps are taken to ensure that they don't cause any public nuisance. And of course, if public nuisance is caused, then there are a number of remedies for that in law.
Just one further thing. So there is flats above this restaurant.
The flat above this restaurant sits at the rear. In fact, it doesn't actually. I have got a drawing of the original planning application for the flats when they were developed in 2019. If it's going to be a benefit to the committee, I can pass that over now.
Okay, hang on. You ready to do it? Any other questions? Regarding the smoking outside, are you going to have a bin of some sort to put the cigarette stubs in?
Yes, sir, we're going to have a box where they can use it. Yes.
I'll tell you why, because I went to a pub recently and they didn't have one, and outside the front door, just littered with cigarette ends, which didn't make it very attractive.
It's not very sustainable.
No, it's always good practice to have bins outside for that very reason, sir, and Sam's experienced to operate and will do so.
Okay. With no further questions? No. If you can just ask questions to the applicants, questions only at the moment, you get a chance to put your case to them. Just ask any questions on what they've said so far.
Yes, sorry. You talked about the deliveries with Uber Eats and all the deliveries of cooked food to customers, and that going via the front. Equally, from what I can understand in viewing the detail, you have determined that you want to do deliveries of supplies to the rear, and I don't actually see how that's going to work, because supplies to the rears having deliveries that way is going to cause nuisance, just like the customer deliveries like Uber Eats and Deliveroo. And my question will be: is your intention to do deliveries to the or via the rear? Because none of the other businesses do deliveries via the rear. So I just wanted to ask a question first. Sorry, it's a long-winded question.
Okay, so at this stage, the intention is to do the stock deliveries to the rear, which may be 10 minutes, 15 minutes, 3 or 4 times a week. It's not, obviously, the difference between Deliveroo is that there. Hopefully, they could be every 2 minutes. You know. But this is no comparison whatsoever to the delivery drivers who are taking food away. This is simply stock deliveries. Yeah, so it should not cause a nuisance.
So have you any further questions? Just questions at the moment.
Okay, well, it depends on the question. As far as my understanding is that you do not have a right of way over the area at the back to enable you to use vehicles to actually stop and produce deliveries or do deliveries. So that is kind of a question. Do you think that you have a right of way to do deliveries via the back?
So may we just pause on the right-of-way questions until the next stage about representations, unless we're on that now, so we can go into that in more depth.
Okay.
So I have one more question. In the statement you mentioned, which was page 42, where you've got the agreed 5 points, am I correct in understanding that you've agreed points 2 to 5, and they'll be part of the licence, and point 1 is going to be part of policy because you talked about there being against fire regulations or whatever it was. So that's your interpretation at the moment, and that's what you're putting forward, just so my understanding is correct.
That's correct, sir. As I said, I was appointed late, so I went, I think the following day was the earliest day we could both meet up and do the walk round. So it was just trying to get the right tool to minimise any potential impact on residents or anybody else, negative impact, I suppose. Yes.
No more questions at this moment.
So if you'd like to present your case while you're objecting to the application, please.
Sure. So I originally put in a lot of via the standard procedure about prevention of nuisance to public nuisance and harm to children, etc. And to be fair, the applicant has addressed a lot of those in that page 42 statement, which is great. So about noise, and why do I mention it is because the previous licensee did cause an issue, and one before that caused an issue. So I'm not doing this just to be difficult. I'm doing it based on experience, and that's why we sort of said keep the bins always closed and locked, because otherwise somebody will just open it and chuck their rubbish in, and they'll leave it open. You'll get flies, wasps, rats, blah blah blah. So that's why I say keep it closed, which you've agreed to do. So you've accepted sort of the points that I've made, which is great. I had some other issues. One was about deliveries. We'll come on to that because that's obviously going to be an issue. So another one is all I can say, it's an enormous extractor fan that has been put around the back. There was one before, which you've taken down. That never worked properly and was quite noisy and was basically rebuilt and made to be a lot less noisy. You've taken that one down and put in a new one, which I haven't heard, so I've no idea how noisy it is. It may be noisy, it may be not, but it is a big thing. It's like 25 foot tall and then points to the to the front towards the high road. It's not a sort of, like a small extractor fan, it's an industrial unit. So I wanted to have a way of, obviously it might be fine, I don't know. So there needs to be a way of residents being able to contact, for example, yourself by phone or email or whatever to discuss any particular issues that I had. That was just one I mentioned. The bins, I'm assuming you're going to have a biffer bin. That tends to be quite a large thing. That needs to be outside, just outside the back door of the restaurant. we've had problems before where people have decided to put it in the generic area, and again, that leads to people dumping stuff next to it. It leads to smell, especially in the summer, so it needs to be outside the back door of the restaurant where it's supposed to be and where there is space per the plans when they're originally done for that bins to be there, so it needs to be there. And then it would be collected hopefully between 8 and 6, and I put that in there in my request because, you know, we've had biffa bin collections at 4 o'clock in the morning, and they love making a bit of noise, don't they? So they wake everybody up. Okay, so that's what I'm saying. If you're going to get biffa to do it, you need to say to them only after 8 o'clock, and I'm trying to be realistic based on experience. You know, there is room to have those bins next to the rear door of the premises, and it should work fine. And then you can sort of, you know, get biffa, they will come round and they'll do it via their normal delivery method, their normal collection method through Smarts Lane Mews. Then we move on to, there was one other, the hours of operation. One compliment, your TripAdvisor reviews of your restaurant in Canary Wharf say it's a fabulous restaurant, so I'm looking forward to actually using it. There's not many ways you get the things there, it's absolutely fabulous, so that's great. One thing that I was concerned about is there was, and this may be a one-off, somebody was doing karaoke in there, so I was kind of hoping you're not going to have karaoke evenings and what have you, in which case the door definitely needs to be shut, and you talk about noise limiters, etc. So I just mentioned it was one of the reviews on TripAdvisor, but generally your reviews are great, so I look forward to actually coming in and using the restaurant. So in terms of the hours of operation for alcohol and music, that's fine. You've said it's not live music, it's recorded music. I accept that you want an early licence because you might have the Indian breakfast parties and what have you, or weddings, whatever they are. That's great. I heard on the original thing you said you wanted it to be started from 7 o'clock in the morning. That's early for an alcohol licence, but yeah, 9 o'clock. If you're going to do the breakfast, I've got no reason to query that. It's fine. So that was that one. The other one was basically the deliveries. So in terms of deliveries, you've accepted that the Uber and Deliveroo, they're going to cause a nuisance, and they do. Everybody hears the motorbikes revving their engines, and they're a nightmare. So we don't need those. All the other businesses, okay, they're not restaurants, but they are businesses. They all have their deliveries through the front of their shops, okay, and they also put their waste and refuse out the front as well. So that's just one thing to bear in mind. They don't have, or you at the moment don't have right of way for vehicle access. And I appreciate you've been using it because you've been doing the shop and what have you, that's understandable. And although that caused problems for my learned colleague here. I'm just thinking in terms of you don't have vehicle rights, and parking a van on Smarts Lane, trying to unload it, is not practical because Smarts Lane is a very small road and you just block it. Yeah? So you won't be able to do that. So it's more practical for you to do deliveries around the front of the restaurant, which is how the previous licensee used to do their deliveries. Okay, they might park in the car park and somebody might come along with a crate of scotch or whiskey or whatever, or vodka or whatever, and they carry it through. That's not what I'm sort of saying is delivery. I'm talking about delivery of your meats, your fish, and all the good supplies and what have you. So I'd like you to be consistent with the Deliveroo and Uber Eats and do all your deliveries around the front. That will avoid any nuisance and noise to the neighbours. So that was my main aspect from that. I think I've covered everything. What I would say is I've no objection to a granting of a licence. I look forward to it, and Loughton needs another restaurant. We don't need, I don't know, another nail bar, or we need restaurants and places to go. So I'm not trying to be objectionable. I'm just trying to get the right terms and conditions for the neighbours.
Okay, thank you. Anything you want to add?
So can I comment regarding the right of way, or do you want to wait till later? Because the gentleman said he wants to leave it till later.
You've got to say why you're objecting.
Because they have no right of way, and they also have no walking right of way. It's alongside 19 and 17, and I've provided title deeds because I've actually seen, not with this gentleman, but prior and his existing neighbour, These pictures I've supplied, some of them are current, they're not old, and it's been continuous battle. And there's 13 flats, so that's 13 bins. They get left there until collection. Some put them in before. You can't get through. And if we're going to have a biffer as well, it's industrial, it's a muse. I'm the one that actually named that area because I was the first flat there. So we named it Muse because we thought it'd be a nice little area, residential, and there is no commercial access. No one commercial uses the back. There's elderly, there's children. I've even got pictures of one of the children playing in that Muse. Moped or van or anything going through, deliveries, as I've shown you a picture, it is noisy, it is obstruction, and it ruins the fact that it is residential. The back is residential, it's not commercial. And that's why I'm really concerned, because it's been a battle, and thankfully Costello from your, environmental department, he's had to get involved because it became a major issue. And when I've spoken to solicitors, they said the fact is if it becomes, the fly tipping becomes major or coming and going through right away that where you have no access, then you have to take it further to protect your property because it brings vermin. Unfortunately, the owners of 156 and the 154, even 152, they never got involved. It was a battle with the tenants. And it's only because environmental got involved. But my concern is I don't understand why this is deliveries is from the rears and it's even coming up for discussion. There's no access, full stop. It's a right of way which has to stay clear. And I have to even, this was a battle. That's why I wanted you to see how bad it becomes. Unless the residents stay together and support each other, even the commercial, it's going to happen again. What if a delivery comes through and a bottle gets smashed? Who's going to fix that? Who's going to knock on a neighbour and say, can you clean this up? And like even the residents, that's a lot of residents there, coming and going and deliveries are coming through. It becomes commercial. But we've named it Smart Slane Muse for, to keep it that way, to keep it nice and clean. So I'm just concerned why it's even come up as a conversation when they don't have right of way on foot or vehicle. Foot isn't the issue, technically. It's the fact is deliveries back and forth, it becomes commercial.
Okay.
Thank you.
Can you just turn your microphone off, please? Mr. Newman, you want to comment on those objections or between you?
Yeah, of course. So I appreciate what's been said so far, and I'm going to have to consult with some people on various points. But and thank you, Mr. Richardson, for some of the positive points, balanced points you made. So, firstly, if I may deal with the extractor fan first, because that may be the simplest thing. May not. I don't know if it's size or output. I have no idea. Again, it's each application on its own merits, all applicants being different. Do excuse me. Could I consult my colleagues about the extractor fan?
Thank you. Regarding the extractor fan, I've actually increased the size just by only, I think, just a little bit. But this fan is a very good fan which has silencer in it. So I invested over £24,000 just to make sure the neighbors are happy on the extraction fan. Long back ago, I used to live next to a restaurant, which used to be very noisy. And I've just agreed why, I'll tell you, because most of the points, because I used to be in that position where I've always been disturbed. So I'm very mindful of it, that not to disturb the neighbors. That's why the fan I consulted, I had a consultant who came in through, said that fan is not enough for the cuisine which I'm having. And then I invested extra on it to make sure it's just not a fan, has silencer and all those. So I've got to use it to see how noisy it is. If there is required for more silencers to make it less noisy, I will do that as well. So on...
You can do a decibel.
Yes.
Quite happy to do a dB rating, if that would satisfy you. A decibel rating for sound pollution. Yep.
any comments on the objections at all? You go. Councillor Land.
Thank you, Jeff. One question was on this rear access.
Sorry, sir, I was going to go through all the objections. I thought I'd go through one by one.
Okay, let's go through the objections and then you can cover it and I can ask questions afterwards.
Yeah, okay.
If that's acceptable, thank you. I think before anything else, and I'm a licensing consultant, so this is beyond me, which is why Mr. Dennis Frank is here. And whilst Trusted Licensing Associates said it wasn't a matter for licensing, I felt there would be some questions. How deep we go into this subject, I don't know. Honestly, I don't, because so in terms of Ms. Sammy has said about access and use for the rear, whilst with help from Mr. Frank, we've supplied some limited documents, and I don't know if the legal advisor can assist, but our position, excuse me, do my best not to die. Not well.
I'll take over if he passes away.
Yeah, well, whereas it's always nice to have another consultant in case you pass away in the hearing. Every time. But we've put forward certain documents. We have an argument to say that there is legal right of use and access. I'd like a view from legal, if possible, about how deep we should go into this. Sorry, excuse me. Can I have a couple of minutes? Yeah, I want to hear the legal. So we do want a view from legal about how deep we go, because, excuse me, this going into the depths and the weeds seems to be a matter for other courts, other hearing, other legislation, because it's civil commercial. Sorry, can I have two minutes, please?
Yeah.
Thank you. If I look back in a couple of minutes, just go.
You'll have a 5-minute break if anybody else wants to go anywhere.
Apologies, I was expecting more issues from my knee operations and the side effects. So, Chair, the question remains is how far into this subject of right of access and right of use we should go, given we've put certain documents forward and it comes down to commercial law. I don't know whether you want to consult with your legal advisor or not.
Oh.
She's gone.
When you went out, we said we'd have a 5-minute break if anybody else wants to go out. She's gone. Be back in a minute.
Wait for her to come back.
Yeah.
Do you want one of these?
Donna, I think Mr. Newman has a question for you.
Ma'am, what I was saying is, whilst we put as limited amount of documentation forward as possible on use and permissions regarding the Muse, etc., and Mr. Frank has been... Mr. Fisher has frankly inundated me with documents, but I don't want to put them all forward because there's quite enough going anyway. But our argument is we believe, and Mr. Fisher can expand on it, that we have a proprietary right to use and access that particular land. However, and here's the point, how deep do we go? Because that seems to be a commercial issue that should be dealt with by other bodies, other legislation, commercial law, which I know nothing, which is why Mr. Fisher is here, because our discussion should be focused on the promotion or undermining of the licensing objectives. So how deep do we go into this matter in this room here? Sorry.
I've only just literally picked up these documents from the printer because obviously they came through quite late, but presumably it's Miss Bastick. These are your documents in terms of you've provided the property register. Right, okay. I mean, from the purposes of this meeting, I would have thought that this is something that if it's, obviously we would need more time to check it than just having looked at it for 5 minutes, but from the point of view of what Miss Bastick is putting forward, I would have thought that the council would probably have to err on the side of caution in respect of rear deliveries. It's not about the front, is it? This is just about the rear. So this, from what you have explained, would affect the delivery of stock. But I wouldn't want to commit myself at this point, and I would have to speak probably to the residential lawyer here to look at this right of way in more detail. We couldn't just make a decision on it in sort of effectively 5 minutes, unfortunately. As I say, this only, I believe, came through this morning, didn't it? Because I know I printed everything out last week. So not wishing to be non-committal, but I think this is only in respect of rear deliveries, isn't it? That this issue is arising regarding right-of-way, unless I've missed the point here.
No, that, if I may, that's exactly it.
How much information you need in respect of proving that you consider you have a commercial?
Well, what I'm saying is that we've put a number of documents through, even so, to demonstrate that we genuinely believe that we have a right of way and a right of use which touches on everything at the back as we're coming on to bins. However, to go into depth on this issue, this probably isn't the right forum to discuss the commercial issue of who has right of use and who has and all the other related rights, because it's a licensing hearing, looking at the 4 licensing objectives. So what I'm saying is in terms of a determination, we can clearly touch on it because anything that impacts the residents has value, but I'm just saying we shouldn't be going too deep in a licensing hearing because that's subject to a commercial legal dispute, potentially. Is that right? Yes.
Any comment or?
Well, I would have thought that from the fact that we're here discussing this matter right here it possibly would be a good use of it. I mean, but without legal, I can't see how the committee can agree a licence which possibly is in breach of a right of way. I mean, I think that would cause difficulties. And I think the issue in respect of the rear of the property only is what's in issue from what I can gather. It's whether or not, and your point being you want deliveries to the rear of the property of stock deliveries. So, and that is the issue here, isn't it? That from what the objector is saying, that's what she's saying, that there is no right of way. So if that issue is something that you want to, I cannot see, and I'd obviously have to have a quick chat with David King. I can't see that we would, it would put the committee in a very difficult position in respect of deliveries to the rear.
Can I make just a point? There is the 154, which is where this is. They have a historic right-of-way down between, it's an alleyway between 17 and 19 Smarts Lane. Okay, so they do have that right, but that is a small alleyway. You can't get a biffa bin down it, and it's overgrown and is not utilised. So just to bear that in mind, what we're talking about here is deliveries. Nobody else does deliveries, so you should do it via the front. And just to complicate matters, you don't actually have a right of way to use what other shops that are nearer the Hollybush pub on the other side, they have access to, so it's quite convoluted. But I'm just saying in practical terms, deliveries in theory, to make it easy for everyone, should go to the front. So if you want to resolve the issue today, then that's the easy solution.
Thank you. Just before I get Mr. Fisher back in on this topic, given what's been said, we're saying that we've got a legal right, or I genuinely believe we've got a legal right of use and so forth for that area. Just before I introduce Mr. Fisher to expand on our point of legal right, because if it's going to be heard here, we need to go into that, even though it may or may not be right for a licensing committee. I don't know if you wanted to consult with Mr. King.
I think Mr. King wants to.
Chair, my view is we need to be mindful that we're here to determine the application for the alcohol licence and the licensable activities only. So by that I mean, for example, if the applicant wished to open tomorrow as a restaurant and not serve alcohol, we would have no control or be in a position to condition that operation at all. So our primary concern is purely the licensable activities that are applied for, and that's the sale of alcohol and the regulated entertainment, and how that will impact the key licensing objectives. So we do need to be mindful, not stray into other areas. I'm not a property lawyer and I'm not too sure about the rights of way, but we do need to be mindful as a committee exactly what it is we're considering, and we're purely considering the sale of alcohol and the regulated entertainment. So I hope that helps.
Okay, thank you.
Yeah.
Mr. Newman.
Thank you.
Well,
We concur with that. Well, so you're the chair. Do you want Mr. Fisher to elaborate on our position, or shall we park it? Well, sorry, bad expression. Or shall we leave that point there for today?
Yes, please.
Just wanted to raise a point. Now, if this rear access is a condition of the licence, then we can't ignore it. But I defer to Mr. King. Is this going to be a condition of the licence?
Regarding the rear access, you can look at it in terms of conditions of the licence, but I'd actually go back to one of Mr. Newman's earlier comments and concerns that he raised that, for example, that the condition regarding keeping the door closed may impact on other legislation. I'm not entirely sure I agree with that statement in terms of health and safety. If that's a fire exit, which I assume it is, as long as that's kept clear at all times and it's not locked, and therefore it's needed to be used, then that's fine to keep the door closed. It's quite a common condition that we see, for example, when we touch upon noise nuisance in licensed premises. Quite often windows and doors will be kept closed. So it would be permissible to attach conditions to the licence, but again they should relate to the licensable activity not the general operation of the premises. And again, go back to the earlier point that tomorrow the applicant could open up as a restaurant as long as he's got the correct planning use and he can operate. He just can't sell alcohol. So that would be the only difference. So we've got to remember that any conditions we attach should be specific to the licensable activity and the potential negative impact that they may have. So I hope that helps.
Thanks, sir. And on that point, thank you, Mr. King. Very helpful. On that point, the reason it was raised about health and safety at work is Sam made the point to me that in his kitchen it can get very hot given the nature of the cuisine. Therefore, staff might occasionally need to get some air. That's where the Health and Safety Work Act comes into it. Of course, and Mr. King's quite right, there's nothing to stop the operator from opening up. In any case, he's a responsible man trying to do the responsible thing. Of course, he could always open up and do a bring your own. You know, there's nothing in law to stop it. This way, he's regulated, trying to do the right thing. I'd say you've seen from, hopefully, from the history and the demeanour and the experience and the accolades that this is an operator that is what's the word? Responsible and considerate of his neighbours and knows what he's doing, quite frankly. So, so in terms of bins, just going back to that, we take that bin, should I say? We take that on board. We've offered, you know, as long as the provider can do it, between 10 and 6. I've experienced myself with somebody totally different. Bad talk about somebody totally different because we're looking at this operator. But if anybody like a provider doesn't do what you want them to do, then of course you're raising it with their top management to try and sort that out, so it's never an issue. Sorry, Mr. Fisher is chomping at the bit.
Can I just, I'm not sure if you've seen this or not, from Epping Forest's refuse department, a letter, an email from Mr. Coletti. This related to the planning permission that was granted for the flat above 154.
So can I ask what's on that? 'Cause
Oh, sorry.
Yeah.
I thought you would have seen it. Can you pass it on? I'll do it.
No, it's right then.
I've got a bad knee.
Can I just also, am I allowed to say something?
Yeah.
Okay, so in respect of when applications are made for planning, because I know obviously I've done it myself, I know 100% because I've got to go through enforcement for breach of planning for 156, I need to take that further. I know for a fact, and land registry, I provided something, I don't know if you've seen it, where it's commenting they've got rights of way and they're saying it's a statement of truth. It's a comment and an observation made by the vendor. It's not legal. It's what they're claiming. Now, the thing is, the council, planning, land registry, they rely on the applicant to do the research. I paid for a conveyancing surveyor to show my boundaries. There are no bins or from any properties from the 18 flats, other than the dispute I'm going to have with 156, on the right of way obstructing. And what I'm going to read this now, but I know for a fact comments made to planning is based on the vendor doing their research, their legal work, their legal people, before they make that comment on their application.
I am fully aware of that, but I've also...
I appreciate that, but there's been a breach with a few times now, with respect of the right-of-way now, the access. Their access is alongside 19, not on foot. Not on foot and not with a vehicle.
I had to leave that on because I was double parked around there, but I'll have to wait.
So before we go further, I just want to bring us back to Mr. King's point that we should be looking at the licensing objectives, because this is a commercial dispute.
Yes,
My colleague is willing to answer, but should we, sorry, but should we go back to the licensing objectives for the question of today's hearing, which is the point, or shall we continue to expand and go back and forth with this point?
Yeah.
Yeah. Keeps the licence condition for the alcohol and music, and that has to be taken up as a planning issue.
Yeah. Just stick to the licensing conditions of alcohol.
Thank you, sir.
This is also to do with the flat, not the business, in relation to 5A. This is in relation to 5A, this. So it's a residential, not the business, right?
Okay.
Thank you.
We know.
So, do you need a break to sort out your parking? I don't know about other people as well.
Sorry?
Do you need a break to sort out your parking? I don't know.
No, I'll do it in a minute.
Yeah, so just going back to it, we're responsible operators, clients anyway. Parking is not a consideration. Obstruction, of course, can be. There's going to be instructions to any drivers or riders to comply with the law, obviously, because that's what we should do. I don't think there are any questions related to the licensing objectives that are unanswered, unless you want to dig into those answers, sir.
Any questions at all?
I did have one question. I'm not clear. What's the start time in the morning? Was it 7 o'clock or 9 o'clock? I think it was originally 7.
Opening times, do you mean?
Yeah.
7 a.m.
So it's still 7 a.m.
Opening times.
Is that reasonable, given that well, all I'm thinking is that you've got lots of staff coming around, not lots, but a few staff coming around the back making noise first thing in the morning.
Sure, that's incorrect, actually. Sam will answer that.
Originally, when we applied for the license, we applied from 7 a.m. And since the objections came in, then I reversed it on the second letter to 9 a.m. Yes, that's what I reversed it on the second letter. Yes, you're welcome. No problem. Also, regarding the bins, just outside the restaurant in the rear row, I just cannot keep a B4 bin there because there is a fire door. So I can, if I come with you to the site, if you tell me where to keep it, so I'll make sure it's there and it's done.
On your
Yes.
boundary, within your boundary, it's pretty
Yeah,
obvious.
but
Not on the right of way.
Sorry, I can't answer that. Ridiculously means I can't answer that.
No, I don't think.
I'm
I think there was
to
a,
visit with, to meet you and discuss where the bin is, just so
I think
we
there's
can
a
have
lot-
clarity. That helps.
sorry, I think there's a slight misunderstanding there. Sam will keep it on his boundary to the. If you're looking from Smarts Lane to the right of the exit door. Yeah.
Wherever it's best for the resident.
Only within the boundary of his demised lease premises.
Sorry, people, I think we need to keep to the sorry, respectfully, to the matter in hand for right now. But it's a very good question about the opening time. Thank you, Bronte. Sir.
Okay. I think there's got just last points to raise, I think, isn't it now?
You asking for closing?
Yes.
All right. Yeah. To reiterate, this is. Excuse me, if my client wants to just say something in closing before I conclude, if I may.
So I've been operating in the hospitality industry over 15 years, and I've worked with Prathamanja. I used to work closely with the CEO of that. I've done many restaurants, and I've been a consultant for a very long time. And even at the current premises in Canary Wharf, I've got drunk policy. I've got weapons policy. We've got grandchildren conflict management policy. and we've got sexual harassment policy, and equality and diversity policy. These are all which I operate right now. And also, we've won, one of the awards was not mentioned, was Best Bar None Awards. It is one of the major awards from Tower Hamlets Council, where they have scrutiny of many, like chair like this, and they select from the entire UK the responsible operators, and I won twice over that from the entire council, and that has a variety of security, bomb search evacuation policy, fire evacuation policy, prevent of crime and disorder, especially the drunkenness, drug awareness, or even in the toilet, how do you keep all this, public safety, premises issues, glass, slip trace, fire, food hygiene, counter-terrorism training, security briefing, burglary and disorder, prevention of public nuisance, especially noise, smoke, prevention of children, crime scene report forms, risk assessment, barred lists, closure, CCTV camera, working with the police, and staff training records. So I've been really well versed with that. And coming forth to Loughton, it's something will be, Grand Cholan will be extraordinary restaurant. And I come from Cholan dynasty. It was the only dynasty when the British Empire ruled, gave as Imperial Cholas. So it's when the British Empire ruled, they gave that name. And my uncle is escaped persecution from Germany, and he settled down in India. I'm also coming from that route as well. So I will make sure the neighbors are kept, the standard of the restaurant is kept really high. I'm investing a lot of money into it. I just bought the restaurant. It was good as to operate, but still I've just taken down everything, redoing everything to the very high quality. And you will not find any trouble with me. I welcome the locals. All my local who gave reference have always said I've operated in a very high quality level. I never, if, say for instance, if there is any or anything, if they suggest, I never said no, because they're also becoming my customer, and it's going to be a long-term relationship. So I would keep the premises very well. Yes. Yes.
Okay, thank you.
Thank you.
Just summing up, without introducing anything new, anything else you want to say before we retire?
All I wanted to say is, presumably you're going to make a decision when we retire shortly. Are you going to keep the statement that was page 42, which was what Sam had actually agreed to already?
That we'll discuss.
Oh, you can discuss, but I just want to make the point that was all.
Can I ask about the right of way with deliveries? Is that going to be decided? Because, as I said, there's proof there's no right of way for deliveries, and there's also children where you can see vehicles parked. I provided photo where they're trying to squeeze past any form of delivery from the rear, which they don't have the rights. Any form of vehicle there, whether it's 5 minutes, 10 minutes, no one can pass through.
Okay.
Thank you.
Right. Any other officers or lead department want to comment?
So I was just, as I said, I was just going to conclude myself. That's quite a comprehensive answer. However, I'll just make the point of clearly a good, innovative, responsible applicant, and as stated, and a thread that runs through licensing is to reduce the regulatory burden on licensed premises with no unnecessary conditions, what have you, because it's tough in hospitality these days, but it will be a welcome addition, we feel.
Thank you. Thank you.
Let's go. Are we staying here? Are we going?
Are we going? Yeah. So we'll retire and consider the application and be back as soon as possible.
Yes. Can you just pass my...
This is the licensing subcommittee decision sheet for an application for a premises licence under the Licensing Act 2003. The premises addresses Grand Crown 154 High Road, Loughton, IG 104BE. The Licensing Subcommittee considered an application for a premises licence for Grand Crown 145 High Road, Loughton, Essex, in accordance with the details stated on page 10 of the agenda. The representations in support and against the application have taken into account, and we have also considered what is appropriate to promote the 4 licensing objectives and the relevant parts of the licensing policy and government guidance. During our deliberations in private session, our officers gave us no further advice. The committee noted all the submissions and representations, both oral and written, made in relation to this application. The decision of this subcommittee is the application for the premises in respect of Grand Crown High Road, Loughton, EG 104BE, be granted for supply of alcohol on the premises Sunday, Monday, Tuesday, Wednesday, 11 to 2300 hours, Thursday, Friday and Saturday, 11 to 23:30 hours, provision of recorded music indoor, Sunday, Monday, Tuesday, Wednesday, Thursday, 9 to 2300 hours, Friday and Saturday, 9 to 2300 hours. As premises will be open Sunday, Monday, Tuesday, Wednesday, Thursday, 9 to 2300 hours, Friday and Saturday, 9 till 12 midnight. Subject to the conditions as submitted by the applicant with this application. The representations which were previously agreed with the applicant and Essex Police so far as they add or supersede the applicant's condition as below. At all times while the premises are open for licensed activities, there are members of the staff able to immediately provide viewable copies of CCT recordings to the police or to licensing authority staff upon reasonable request. All staff engaged on the supply of alcohol on the premises shall have received training in relation to protection of children from harm, including underage sales, how to recognise drunkenness and the duty to serve, not to serve drunk persons. Refresher training should be carried out at least in 6 months. Training records should be kept on the premises or otherwise be accessible on the premises for a minimum of 12 months and made immediately to the police, training standards or licensing authority staff upon reasonable request. And in addition to the prevention of public nuisance, the following conditions: to keep the rear door closed at all times, to keep the exterior waste bins always closed and locked, to organise the waste bins collection from 8 a.m. to 6 p.m, not before, not later. Smoking by staff or customers should not be permitted at the rear. All cooked food collections will also use the front door to collect the packed food. No collection drivers to access the rear door, which we consider are reasonable and proportionate and will not undermine the licensing conditions. The applicant and the persons who have made the representations are reminded of the right to appeal to the Magistrates' Court within 21 days of the notification of this decision. This is the decision of the committee, dated the 4th of June 2024. Well, thank you all for your attendance and declare the meeting closed.